Hi, this is Steve Worona, and you're listening to Campus Public Safety Online from the National Center for Campus Public Safety. Before I introduce today's webinar, here's a brief orientation to the Adobe Connect interface we're using. Your browser right now is showing the title slide for today's talk. On the left side of your screen, you'll see a box labeled Questions and Comments where you can read and type messages. There's a tab labeled Everyone at the bottom of this box, and that's the tab you'll use for all of your general messages, including questions and comments for our speakers. We'll be breaking for discussion several times during the presentation, so please do not hold your questions to the end. You can also send direct messages to a specific person by hovering your cursor over a name in the attendee list. And one of those names is Technical Help, and that's the place to go if you run into technical problems. We're also monitoring Twitter for your questions and comments. Use hashtag NCCPSwebinar. If you miss part of today's conversation, or if you want to see some or all of it again, this webinar is being recorded and captioned. The link will be available on the NCCPS webinars page in about a week, and watch your email for a link to a brief evaluation survey requesting your reactions and comments on today's session. Please take a minute to respond to that survey when the link arrives. We do appreciate your feedback. And now for today's presentation. In the past year, we've offered 2 webinars on campus threat assessment, and each time you've asked for more. So today we are once again welcoming Dr. Marisa Randazzo to discuss the topic, joined by attorney Jeffrey Nolan to provide additional legal perspective. The specific issues that Marisa and Jeff will consider were drawn from several dozen questions submitted by you, our audience, when you registered. Thank you for your active participation in this unique webinar. Marisa Randazzo is CEO and co-founder of Sigma Threat Management Associates and an international expert on threat assessment, targeted violence, and violence prevention. She also serves as Director of Threat Assessment for Georgetown University and previously spent 10 years with the U.S. Secret Service, where she co-directed the Safe School Initiative, a landmark federal study of school shootings. Jeffrey Nolan is an attorney with Dinse P.C., nationally known for his practice in threat assessment, Title IX, the Clery Act, and FERPA. He's chair of Dinse's Educational Practice Group and has more than 25 years of experience representing colleges and universities in federal and state courts and before administrative agencies. Marisa and Jeff, welcome back to Campus Public Safety Online. Marisa, I believe you're going to kick things off.
Steve, thank you so much. And it's an absolute pleasure to be here. I wanted to start out with a quick comment. I have been promoting this webinar on Twitter for a while with the hashtag #StumpJeffNolan. And I just realized as we were going through all the questions in the past day or so that there are some excellent questions for both of us. So I think I may have brought some challenging questions to stump myself as well. But absolute delight to be back and to be doing this webinar with Jeff especially. What I want to do was start with a quick overview of what campus threat assessment is so we are all on the same page and then go right into the questions. We've chosen lots of different questions across a couple of different domains. But also, as a reminder, we will be taking questions live throughout this. So just a quick overview of what campus threat assessment is. Threat assessment, often termed behavioral threat assessment. We've heard it as student threat assessment. It is a fact-finding process, and it is an objective process that's really recognized as the standard of care for preventing violence on campus. It's also recognized for preventing workplace violence and violence in K-12 settings as well. And just a little bit of history, it was originally developed by the U.S. Secret Service as a process to evaluate threats that came into public officials and public figures. And based on research that we and others have done over the years, it has been modified and expanded for higher education settings, K-12 settings, workplace settings, et cetera. The standard of care reference comes just briefly from an American National Standards Institute approved American National Standard, so an ANSI approved American National Standard that actually speaks to hazard planning across a variety of domains for colleges and universities, but includes some really specific guidance that colleges and universities should have some sort of a threat assessment team or a process in place to evaluate threatening behavior that may impact their campus and to reduce risk. So the purpose of campus threat assessment is really to allow college and university officials and others on a multidisciplinary team to gather information about potentially dangerous or threatening behavior, to make an objective assessment about whether someone poses a threat of violence or otherwise preparing for violence, and if so, then to identify and implement strategies that reduce that risk. So it's about fact-finding, gathering information, doing an objective assessment, and then taking necessary steps to reduce risk if there is any risk. Most campus threat assessment programs and the ANSI-approved national standard includes these different components. So having in place a multidisciplinary team, because preventing violence on campus is not just a matter for campus police or public safety or security. It is not just a matter for student affairs or HR. It is not just a matter for your counseling center or EAP program. It functions best when you have all those different entities and others at the table. It involves or should involve high-quality threat assessment training, having some procedures or guidelines to help guide the work of the team, having places where people can report concerns or threats that they know about, and ongoing efforts that the college or university engages in to encourage people to bring threats and other concerning behavior forward. So with that backdrop, we're going to launch into the questions, and the first area of questions that we have is on assessment tools and assessment practice generally. Jeff?
Thank you, Marisa, and thanks everyone for joining us. We really appreciate that. So Marisa, I'll ask the questions of you, and then we'll trade roles when the other is expected to ask first or answer first. So I'll ask a question that was received over the past few weeks from folks attending. What, if any, is the best assessment practice for determining pathway to violence?
So there are a couple of different tools out there or guidelines or procedures out there that I think is important for people to know about. First and foremost, the procedures that are referenced in this ANSI-approved American National Standard for colleges and universities are in two books. One is the Handbook for Campus Threat Assessment and Management Teams, and the other is a book called Implementing Behavioral Threat Assessment on Campus, a Virginia Tech Implementation Project. The second book, Virginia Tech, is available free of charge, and Steve and Andrea, I know, have published this, have published links to it, and can do so again. The first book, the handbook, is currently out of print, and we are talking with a publisher about doing another round. I will say at this point, the prices I've seen for that first book on eBay would fund my daughter's college education. So if you have a copy of the first book, keep a hold of it. But those two books are referenced in the American National Standard. So if you are following the procedure in either book, and they're the same procedures in both, it allows you to basically say, we are following the procedures that are in this ANSI-approved American National Standard. And so I think they help make sure the college or university is following certain steps, and can also document their work in case their work is ever challenged. The other tool that we hear a lot about that I think is a great tool is called the Waiver 21, WAVR-21. And that is a tool that is developed primarily for clinicians to use, but a multidisciplinary team can use it as a go-by as well. But it's primarily developed as a tool for a clinician to engage in a structured professional judgment about violence risk, developed initially in the workplace, but is also appropriate for campus settings as well. Any tool that a threat assessment team uses or a go-by is something that would be good for a team to document and basically say, hey, this is what has guided our procedures, so you can show the work you've done and show the credibility or kind of the recognition of the tool behind the work that you're engaged in.
Thank you, Marisa. I just make one point on that. From a legal perspective, there's a document that Marisa and I wrote with Gene Deisinger some years ago, published by the University Risk Management and Insurance Association. It's an article that's available on the Sigma TMA website, and it speaks specifically about the ANSI National Standard that Marisa referred to, and does some legal analysis as to why using a standard that is vetted and published in the way that one was, and then using resources cited in that standard, like the Handbook for Campus Threat Assessment Teams and the book on the stand-up of the Virginia Tech program, would put you in a better position if you ever were challenged, because any principled expert would have to acknowledge that at least your process, if not implementation, but your process followed what had been identified as a very appropriate set of steps and standards to use. So that is available on the website, so you can use that outline, and I'll speak again to that in a second. Another question for you, Marisa. Is there one assessment approach over another that's good for both students and staff of concern?
Yeah, so the procedures we just referenced in the Implementing Behavioral Threat Assessment on Campus, in the handbook, in the IRMIA article you just referenced, which are the same procedures throughout, are equally good for addressing concerns about behavior wherever they come from, whether it's a student or an applicant or a staff member, a former staff member, a parent. We've had to use threat assessment procedures to address very concerning behavior coming from a parent, against the student where there had been a protection order or a tough family dynamic, a stay-away order. So you can use these same procedures regardless of where the threat comes from. But I also think it's very important that colleges and universities use the same procedures to be able to say we have some standardization, whether it's a student concern or a staff concern. What will differ is where you get information. What will differ are the tools and resources you have to address risk if you see it. But I believe strongly that the process should be the same regardless of where the threat is coming from.
Great. Thank you, Marisa. Would you ever recommend using more than one assessment practice to make a decision regarding a person of concern?
We often see that it can be valuable to include a psychological evaluation, a full mental health evaluation, or a forensic evaluation of risk in addition to what a threat assessment team is doing. But we recommend that only in cases where you think there may be a mental history going on or some other history that it would be helpful to have that information to do. So people often think that a violence risk assessment is the same thing as a behavioral threat assessment. Violence risk assessment is something that a trained psychologist or psychiatrist who's got some specialized training in this area would do, really to look at, is there a risk largely of impulsive violence? Behavioral threat assessment looks much more so at whether there's a risk of planned or predatory or targeted violence. So the two can complement each other well, but one should never be used to replace the other. So getting back to what's expected of colleges and universities, the ANSI-approved national standard and IRMIA article and other references we're citing focus on behavioral threat assessment. So at least do that, but there may be some cases where you identify it's helpful to add on to that a violence risk assessment.
Thank you, Marisa. Can you explain just a little bit more about the limitations on the use of the more clinical affective violence-related assessment tool when you're dealing with a potential for targeted violence? Because I think a lot of folks hope that they're going to be able to skip the threat assessment process and schedule an interview by a trained professional who may or may not have the training in that particular assessment tool, and hope that somehow they will be able to discern that person's propensity for violence. So I wish you'd speak to that.
Yeah, excellent question. We often see this confusion, and it's completely understandable because the terms are similar and the processes sound similar. A violence risk assessment is something that we would do if we think there, as I mentioned, there's a concern about a mental health problem that may be behind behavior. But a violence risk assessment just focuses on risk of impulsive violence. So if you're in a situation where you're having a conversation that turns into an argument and then all of a sudden someone becomes physically assaultive, that's a type of impulsive violence, and that occurs far more often than planned or predatory violence, like a campus shooting in Virginia Tech, Parkland High School, Parkland, Florida, Stoneman Douglas, etc. The training that mental health professionals typically get for assessing risk is just around risk of impulsive violence. And that type of violence, the predictors for impulsive violence don't necessarily translate to being helpful predictors for targeted violence. They're really two different types of behavior. Targeted violence is where we think about something in advance, plan it out in advance. It is different from losing your temper in the moment and being unable to control your actions and becoming physically assaultive. So my recommendation is if you have a case where someone has a history of that impulsive violence, losing their temper, becoming physically assaultive, maybe throwing things across an office when they're being counseled on their behavior, for example, it is very helpful in those cases to involve an outside violence risk assessment by a mental health professional. Because what they will focus on is there any sort of mental health conditions underlying this behavior that we can then treat or manage in some way through counseling, but again, separate from behavioral threat assessment, which is what threat assessment teams are trained to do.
Thank you, Marisa. Another question from folks who are participating. Are there any published guidelines for conducting a threat assessment interview with a person of concern?
So the interview really, what we encourage in interviewing people of concern is not so much to follow a structure. You want to be able to ask about the behavior that has put them on your radar screen in the first place. You know, what was going on? And what I think is so valuable about interviewing a person of concern is that this is your first chance to actually hear from them what they think is going on. We have seen interviews with persons of concern actually be the first step toward managing a case, toward engaging in risk reduction strategies, because it gives that person a chance to be heard. Now, what they're telling you may or may not line up with information you're getting from other sources, and that's what the threat assessment team can then sort through and analyze. But in the moment, in talking with a person of concern, rather than thinking about, I need to cover this base and this base and this base, I encourage people to go in thinking about this is your chance to hear from them. And for a lot of people who are operating under increasing stress, increasing loss, engaging in bad behavior, threatening behavior, giving them some time and attention to tell their side of the story, in and of itself, that interview can start to de-escalate hostility. So my approach to going into an interview is ask them from their side. It shouldn't be accusatory. It shouldn't be punitive. It should not at all be adversarial. So sometimes it can be important to give some extra thought to who on your team is going to be the best person to have that conversation. We have joked a lot among our team at Sigma, for example, that sometimes I am the right person, sometimes I'm absolutely the wrong person to put into an interview situation because there's something about the person of concern that's just I find irritating, frustrating, whatever the case may be. So then we'll put someone nice, like Jeff Nolan, into that situation, for example. But really think more about how to approach this from, this is your first chance to start getting information and start that listening and start a chance to de-escalate.
So as you know, Marisa, I'm going to expand this a little bit because I'm trying to see the intent behind the question and some advice for how to approach, and I think you've provided that really well. As you know, we've been doing a lot of work as Sigma with trauma-informed interviewing in the Title IX Clery area when doing investigations, and then also dovetailing some threat assessment concepts into that world, as we'll talk about later on this webinar. Often that involves using cognitive interviewing techniques or a FEDI technique that ask the person, what are they able to tell you about their experience, tell me more about that, not being confrontational, not interrupting them, and that sort of witness-focused, witness-centered questioning rather than sort of a cross-examination on the terms that the interviewer demands. What are your thoughts about that kind of an approach when approaching a person of concern?
Yeah, I actually think that's a perfect way to phrase it, because it really should be focused on their take on it. What is their perception about their own behavior? What got them to the point where they engaged in that threat, or they're saying the things they're saying, or posting what they're posting on social media? When we can hear from their perspective, not only is it de-escalating, but it's highly informative. We often like to ask questions like, okay, so you're worried about losing your job. If that happens, what will you do? I've worked on cases where the answer is, I don't know, but I'm afraid of what I might do. That gives me a certain level of concern that this person's even worried about themselves and their own behavior. So let me dig into that a little bit more. What do you think you might have? I don't know, I might have to move, or I might be forced to take a job that's lower than what I should be paid, or I might face financial stress, versus I might feel the need to get back at everybody. Okay, so if so, how? You can find a way to ask questions that may seem tough to ask, but in a very neutral way and in a way that you genuinely want to hear what that person's saying, because giving them a chance to talk may be the first time they've actually felt heard in a while. And so for someone facing increasing loss or sort of losing everything around them, that can be very important to stop for a moment and hear what they have to say and why they feel so frustrated or feel like they may have to resort to violence. But B, what they tell us can actually inform our case management efforts and might offer an easier or a simpler fix than anything that we as a team could come up with on our conference call or sitting in our meeting room.
Great. Thank you, Marisa. What makes or constitutes an expert in the field of threat assessment?
And actually, Jeff, I'm going to combine these two questions because I think we can answer them at the same time. So the second part of it is what kinds of training or education or experience would be important in looking for someone you want to hire as a case consultant or a training instructor. Hands down, for me, the most important piece of experience I want to look for in a consultant to train a team to provide case consultation expert is experience working actual threat assessment cases. We've talked about this before, and we've got a blog post on the sigmatma.com website about 5 questions to ask before you hire a threat assessment consultant. But they all boil down to experience handling actual cases. It's one thing to do research in this area, and when I first got into threat assessment, the only background I had was in studying targeted violence, interviewing school shooters, interviewing potential assassins, things like that, but I didn't actually have the case experience. Case experience provides you with an actual chance handling situations, and what we say is there's no magic number, but what I look for typically in people we may want to work with, in consultants that I would recommend for colleges and universities that we work with, is someone who has at least 10 years of being in the trenches working threat assessment cases in whatever domain. Maybe it's in K-12, maybe it was at a government agency, maybe it was serving on a campus threat assessment team, but having that much experience gives that expert a real wealth of knowledge to draw upon, and cases that they've handled, including creative options they may have handled in other domains in their threat cases. So it's one thing to hire someone who has spent a lot of years studying threat assessment, published on threat assessment, done kind of outcome research. All that is helpful to the field, but not necessarily for someone that you want as your guide to figuring out how do we handle this particular case.
Great. Thank you, Marisa.
All right, my turn to ask you one, Jeff.
Okay.
During the question we had here was during a bona fide threat assessment process, during a threat assessment process of an employee, is there any line or type of questioning that is legally prohibited?
Sure. So I'm not going to try to speak to all of the state laws because I'm admitted in a bunch of places, Vermont and Texas and Massachusetts, Virginia, New York, but I'm not going to speak to the whole country. So there may be state laws that apply here to provide particular privacy rights in the workplace. But what I can speak to on a federal level is Equal Employment Opportunity Commission regulations promulgated under the Americans with Disabilities Act. And the general rule there is when you're working with an employee, your questions, if they are likely to elicit information about a disability, a mental or physical impairment that substantially limits a major life activity, they have to be what's known as job-related and consistent with business necessity. Sounds like a fairly broad standard. It is a fairly broad standard. It is quite flexible. And when we're talking about serious safety-related issues, it is going to be job-related, that folks refrain from posing a danger or risk to others, and it's certainly consistent with the necessities of any business that they be able to maintain a safe environment. So if questions that may elicit information about a mental disability, for example, need to be asked in the course of a threat assessment, that could be justified. I would say that it is safest to focus on behavior first rather than diving right into questions about mental disability, because as Marisa, you well know, we don't focus on mental illness first. We focus on observed behaviors. How is this person acting, and not nearly as much on mental illness-related issues, which may or may not have anything to do with dangerousness. So if you focus on behavior first and then go into issues that may bring up mental health issues on a secondary basis, and then if you're ever tempted to be asking about records related to mental health issues, really do that as the third line, and triage it in that way or stage it in that way. That should be consistent with EEOC regs.
Great, Jeff. Thanks. Steve, I think we're turning it over to you at this point.
Tremendous, yes. Thank you, Marisa, and thank you, Jeff. You are listening to Campus Public Safety Online. Today we're hearing from Marisa Randazzo and Jeffrey Nolan with a Q&A in-depth expert dialogue on campus threat assessment. In addition to the questions that Jeff and Marisa have prepared answers to, you are welcome to type questions of your own into the blank line on the left side of your screen where it says questions and comments. We have several breaks planned, and we will ask those live questions to Jeff and Marisa as they come in during the breaks. Hivanto wonders, any suggestions for folks that are looking to grow their experiences, perhaps training prior to managing cases? Marisa, is that one for you?
Yeah, absolutely. I am a huge advocate of getting people involved in the Association of Threat Assessment Professionals, otherwise known as ATAP. The website is atapworldwide.org. ATAP is really the premier professional association for anyone who wants to work in or learn about threat assessment from whatever domain, prosecutor, clinical psychologist, school teacher, whatever the case may be. It is a wonderful professional network. They are the only body that has the Certified Threat Manager certification, which is the only certification recognized as a threat assessment expertise. And they have, not only do they have an annual conference in Anaheim, California at the Disneyland Hotel every year, because Disney Security has long been a major player in the field of threat assessment. But they have a wonderful network of regional chapters. So they have a Northeast chapter, they've got a Mid-Atlantic chapter, a Texas chapter. They are growing. They have chapters all throughout the U.S. So joining ATAP and then attending occasional meetings at the chapter level not only exposes you to wonderful discussions at the meetings, which usually happen every other month, but actually helps you to build your own network of other people within threat assessment that might be helpful for a given case. So I just attended the Mid-Atlantic meeting yesterday. I always learn something at these meetings, and then the national conference itself is a wonderful opportunity to really do a deep dive into the field of threat assessment in the happiest place on earth, which I love.
Thanks, Marisa. I'm going to squeeze in one more item during this break. Keep those questions coming in. We're not going to lose them. But Fred Hainish, and I apologize if that pronunciation is wrong, says, not a question but more of a comment, that I like hearing the use of, quote, person of concern, unquote, or something that isn't necessarily only student-focused. The threat assessment needs to be broader than just students. And Marisa and Jeff, I'm going to leave that for you to comment on as you wish, and let you move on to the next segment on buy-in.
Well, I certainly agree with that. We absolutely, we saw the transition of interest in higher ed from the student focus after what happened at Virginia Tech, but then recognizing that faculty can be involved in those behaviors, as we saw at the University of Alabama at Huntsville, and workplace violence has been a consistent problem throughout our history in our country. So we cannot afford to focus only on students, so I absolutely agree with that comment.
And I just want to echo that, too. This is especially true for colleges and universities, where they are not just a place of education. They are a workplace as well, often for hundreds, if not thousands, of staff. So this process is just as applicable, just as helpful for maintaining campus safety, again, for whatever the source of the threat. And we prefer to use person of concern as opposed to even the term subject. or threatener, because those terms can just kind of inadvertently be a little bit dehumanizing. And so much about what makes threat assessment work well is not distancing and dehumanizing. It's actually trying to get at what's going on for this person, whose behavior is starting to scare people, and why are they acting that way, and what can we do to head them onto a different path away from violence. All right, so I think I'm going to lead off the questioning here. So Jeff, I'm going to give you a first stab at this one, and I can add on as well. This section is on buy-in. How do you kind of build support for having threat assessment generally as well? What strategies would be best for helping convince an otherwise reluctant campus administrator or stakeholder as to the benefits of a trained and certified threat assessment team?
Thank you, Marisa. Before I answer that, I want to hop back to this employment in the workplace, in the higher ed context question. On the Sigma TMA website, there's a resource that I wrote some years ago that talks about the use of threat assessment in the workplace context in higher education. It refers to a workplace violence prevention intervention standard, much like the ANSI standard you spoke about previously, why it should be used, how it should be used in the workplace. So that resource is there on the Sigma website if folks are interested in it. To answer this question, the most obvious, most compelling factors in trying to convince otherwise reluctant campus administrators or stakeholders about the benefits of a certified threat assessment team are the consequences, the risks, the things that we're so concerned about, the potential for violence that may affect more than one person on our campuses. That is the absolute number one thing that should be convincing and should get the attention of folks. If it appears that you need a little bit extra leverage beyond what should be the most compelling thing we can think of, there are definitely legal considerations and some developments that have happened over the last 12 months that really should get the attention of stakeholders as well and campus administrators. There was a decision from the California Supreme Court that came out in March of 2018 in the Rosen case involving Catherine Rosen and UCLA. And in that decision from the California Supreme Court, the court held that there was a duty to keep students safe from the intentional criminal activity, assaultive activity of other students in a curricular setting, essentially was the holding of that. And in doing that, they relied on some principles that have been recognized for some time but not adopted by all courts everywhere. But these are principles in something called the Restatement of Torts that we wrote about again in that 2011 IRMIA article that's on the Sigma website. And it outlines how the use of standardized principles recognizing such a duty could be used by courts. And it appears the California court has most definitely said, yes, we agree that that duty is present. They rely on courts in other places. So one of the things that you see when these kinds of things develop around the country is you'll see courts jumping on the bandwagon and joining their colleagues on the bench in other states. So we see them relying on older Massachusetts cases. And then we see even after this March 2018 decision from the California Supreme Court, a Massachusetts court citing the California court on the question of duty to prevent student suicide in certain limited circumstances. So again, these courts are looking to what others are doing. And as part of that, the California court spoke specifically about threat assessment teams. And on this question of whether they should have a duty or they should recognize a duty, they held specifically that UCLA, like other colleges across the country, have already developed sophisticated strategies, multidisciplinary teams to prevent violence, that's a follow-on from what happened at Virginia Tech and on the basis of various reports that have come out. And the court held because you're doing it, it's not going to impose a burden, and it's no far stretch from that to say because you're doing it, it's going to become the standard of care. It functionally is the standard of care. And the IRMIA article talks about that. More recently, appellate court in California in the same case in December of 2018 held that the case would go to trial because there were at least issues of fact that a jury could look at that concerned whether in that particular case where a person later diagnosed with schizophrenia had stabbed another student in a classroom, issues of fact about whether the care type teams the student support team on campus should have referred that case to the campus's threat assessment team. So again, that question of threat assessment being the standard of care is highlighted right to the fore. I will note that these are all interim decisions, and nothing has been decided yet as to whether the university did or did not do anything wrong or negligent. That remains to be seen. This is just the development of the law. So when you're talking with administrators about this, we have a history as outlined in that 2011 IRMIA article being played out much more recently in cases that are very current and very much, I think, representative of most likely where the law is going. You need to have a threat assessment team as part of your best practice. I think courts are going to recognize that more and more.
So I just want to add on quickly to what Jeff was saying, and then I'm going to combine our next two buy-in questions into one. Basically, when we are hit with a question like this about kind of how do you convince reluctant administrators, the two things I recommend to all the colleges and universities we work with across the country. One, download and read that IRMIA article, or at least just deliver it to the person who is showing some reluctance. That IRMIA article that Jeff was the lead author on really sets the stage for why legally it is so important for colleges and universities to have that threat assessment team. So that article can really help to brief and get that administrator up to speed on what threat assessment is. And second is that if there's a college or university that still has a question, I recommend strongly that they put their general counsel in touch with Jeff Nolan. They can speak legalese to each other. Jeff can help explain exactly what we're talking about here, why there are so many compelling reasons, and why it is no longer acceptable to say, well, I didn't know about it, therefore we didn't have to do anything about it. We have to have these programs and processes into place, not only because they work, but they also allow us to show that we were following the steps we needed to follow. So A, IRMIA article, B, Jeff Nolan as a resource, and let me turn to combine these last two questions into one because they actually speak to a similar issue. So we've got two more questions on buy-in. The first is how to change a culture where threat assessment is new and violence prevention is downplayed, and I'm tying that into our third question, which is how does Georgetown value and use me in my role as their director of threat assessment? So these two questions, I think, are directly related because when I first joined Georgetown as their director of threat assessment, they didn't have a capacity like this before. And we had actually come in as consultants with Sigma to help them figure out how did they even stand up a process. Georgetown is, like many institutions, has different campuses and different locations, and so for them, having just one team wasn't necessarily going to work well within their governance structure. They wanted to make sure there was kind of local knowledge across their different campuses, and the medical school had a different culture and leadership than their law center, for example, or their School of Continuing Studies, which has more non-traditional students there. So we helped them to sort of figure out how to build it, but actually then coming in to run the program was something that we've been able to help other colleges and universities do in sort of building a culture where threat assessment is valued. I will tell you that one of the best guideposts that I had actually came from advice that I got when I started as a psychologist with the U.S. Secret Service, and that was listen first, give advice second. When you are building a culture where threat assessment is new, or maybe where violence prevention is downplayed, what I look for is what are the strengths of that culture, what is already working, because threat assessment should help to harness what's already working well within a structure and then sort of fill in gaps where information is missing or processes are missing or resources are missing. But to do that, if you're coming in as a new director of threat assessment, if you are standing up a program and you're there as a chair of a team, for example, but you also wear other hats. You're in the Dean of Students office, or you're in HR, or whatever the capacity might be. I recommend being patient, because building a new culture and building a new mindset takes time. And the more that you can spend listening to how are these situations already handled, what do people think are working well, and try not to disrupt that, but then add on to that. Listening, whether it's interviewing a person of concern, building a new program, trying to change the culture, listening goes immense distance in helping to make that outcome possible, that beneficial outcome possible. Stephen Covey, I think, wrote this in the 7 Habits of highly effective, influential, whatever the 7 habits were, the initial book. Seek first to understand, then to be understood. And I think that guidance is really important, again, and whether you're interviewing a person of concern or trying to create buy-in for a new program or a new position or a new culture within a college or university. I think we are at more questions. Steve?
Yes, thanks, Marisa. Keep those questions coming. We won't lose them. We've got a couple more breaks scheduled. Both Karen Thorderson and Greg K. are asking for a citation for an article that one of you just mentioned. And Jeff, I guess, is that the one that you did you just answer that question? Was that the
the ERMI article is posted on sigmatma.com, so I just typed in the web address for that. The workplace one is posted there. The ERMIA article is posted there, and there'll be some other articles I'll mention in a minute. Those are on my website, which I'll type in the URL for when we get there.
Tremendous, thanks. Matt Hart wonders, how can an institution without a case manager, either part or full-time, ensure its behavioral threat assessment program maintains efficacy? Do you see a marked difference in program effectiveness between programs with and without a case manager? Marisa?
So excellent question. I'm a huge proponent of case managers, but many institutions have to go without them. What I would recommend is that the case management function is really the function that helps to keep track of individual people of concern when we feel like we need to do more than just the assessment. If we think there is some risk, if we think we need to engage in some threat management or risk reduction strategies or help connect them to resources. What I see teams without a dedicated case manager, and many institutions have no dedicated case manager, what I see teams do well in the absence of a dedicated case manager is to share the workload. So in a given case, you can go through the assessment. You may have a chair of your threat assessment team. You go through the assessment. For those cases where there's some ongoing follow-up or case management or monitoring that the team thinks is needed, then choose from among your team as to who is going to do that. You can have it as a rotating position. You can do it as a strengths-based approach to figure out who's going to be the best person for this particular case to serve as that liaison role and make sure things are getting done. But so you can share the work. If you can advocate for even a part-time or shared case manager position, I've seen that work well across colleges and universities too. So sharing between I've seen a shared case manager position between the police department and HR. I've seen it shared between Dean of Students Office and Counseling Center, between Res Living and Dean of Students Office. So you can see, hey, maybe we can't fund a full-time dedicated position, but can we fund a part-time, and who's the right other department to share that if they're able to foot that. But even without a dedicated case manager, you can share the load by figuring out case by case, only for those cases where you need to have ongoing risk management or risk reduction strategies and monitoring who's the best person for this case or whose turn is it next.
Thanks, Marisa. I'm going to combine a bunch of questions into one, and this will be the last thing we try to squeeze in during this break. They all have to do with individuals leaving the institution. What techniques can be used? So there's a 3-part question from 3 different people. What techniques can be used to monitor a student who has been identified as a threat but has left the institution? What is the best way to work with non-affiliated individuals who might represent a threat, such as a student who has been expelled and restricted from campus or a parent of a student? And when a BIT or TMT is working a case, but the individual will soon no longer have a student status, who can we best inform or hand a case over to, that is, which agency? We've struggled with cases that are across agencies, etc. Jeff, can you dive into that first? I guess both of you will want to address it.
Well, they're definitely.
Jeff,
go ahead.
I was going to say, Jeff, if you tackle the FERPA aspect of it, and I can handle the non-FERPA. What's allowed to share?
Well, in terms of sharing information outside to other entities, yeah, I'm gonna hold that one because it's coming up in a whole slide a couple slides ahead, so I'll hold on that one. Why don't you talk about the practical aspects around dealing with folks who are outside the institution and how you gather information about them and try and engage?
Yeah, and this is a challenge for teams generally, and it's actually a point where it's important to really give some extra care. When we have someone who's in our college or university environment, and we think they pose a threat. So let me be clear that the concern is we don't need to be concerned about forward notifying if we've made an assessment. We don't think this person is on the pathway to violence. We don't think they're preparing for violence or at imminent risk of suicide, for example. So if we don't have that concern, if we don't think they're a case that needs to be managed, and they leave our environment, there is much less of a need from a safety standpoint to forward notify, and I think that's okay. Oftentimes we have cases where someone may be engaging in threatening behavior in our environment, but once they leave whatever the dynamics or situation is, whether as a student or an employee, for example, and they go on to their next school, if they go on to a new job, they can be quite successful in that new environment. So we have to figure out the balance of notifying because there's a safety need to do so versus allowing them to go to their new environment where they may well be quite successful because they're no longer under the stressors of the current environment. So there's a balance. So I encourage teams to focus on thinking about forward notifying or thinking about how to monitor someone who's left the institution, that the real focus needs to be when we think that person still may pose a threat to our institution or to people here or to the community broadly. In that case, when someone leaves, oftentimes we have very limited options in which to monitor. A couple of things that we recommend. One is publicly available social media. So if they're posting things on Instagram, Twitter, anything that we can see that's publicly viewable, it's okay to use that. We've been reassured when we've seen people post about how good their new job is compared to their old, and they may still be slogging the old job, which is the campus where they used to work, but they seem to be happy in their new environment, whatever the case may be. So social media that's publicly viewable is one source to be able to monitor how someone's doing when they leave an institution. Second is to see, is there anyone at your institution that still has some relationship with them and is willing to give you information, and that second piece is important. So we don't want to put someone in an awkward role, but if someone has already come to you and expressed concern about their coworker, about their friends, about their roommate, you can then ask, hey, I know they're going on to a new situation. If you happen to hear how they're doing, good or bad, it would really help us to know. I hope they're going to be successful, but if you have additional concerns, you have a view into how things are going for them that we don't have. So it would be helpful for you to share that with us so we can find out how best to support them. Using support-focused language, using if you happen to, and if you're concerned, let us know. Not, will you be checking please check their Instagram feed every hour on the hour and let us know what they're doing because we may need to increase our safety posture here. Right? That's not the approach. Help-focused monitoring. If you're concerned, let us know. The other is to notify local law enforcement or campus law enforcement where that person goes to next. Now, that notification is something that Jeff can talk about in just a second as we get into information sharing, and there are things to consider about that. Some of the best forward notification I've done from a practical standpoint, not factoring in the legal issues for the moment, is oftentimes a campus security to campus security or campus police to campus police, whatever the case may be, to basically say, hey, we had this person at our institution, and they're now within your environment, and we hope that they're going to do well. But if they raise concern, there may be information we can share, or if they come upon your radar screen from a policing or a public safety standpoint, it would be helpful for us to know, and factor into our information here. So again, we don't want to stigmatize someone going forward because this may be leaving our environment may be the best thing for them in terms of reducing risk. But at the same time, there may be a case where we feel for safety reasons we need to alert folks in the next community, next campus, for example.
Okay, thanks, Marisa. Again, all of you out there, keep the questions coming. We've got a couple more breaks scheduled, but in the meantime, we're moving into info sharing. And Jeff, I guess that's yours, but let the dialogue go on.
So Jeff, let me read the question to you. So related to digital documentation, how can you collect, track, and analyze student-level data, related to mental health, threat assessment behaviors that is protected under FERPA and HIPAA and not subject to open records requests.
Sure. Thanks, Marisa. So there's a lot of elements here. I'll try and answer as best I can, and you can help as well if you would. So when we think about the different types of records that are talked about here, and this is obviously describing the process that a behavioral threat assessment team would engage in analyzing, in this case, student-level data, and referencing FERPA in particular as to students. We think about student treatment records, which for the most part are not going to be deemed FERPA records. Those are exempt from FERPA. They're going to be, when they're in the hands of the clinicians. So if you have access to those, it's because the clinicians have determined that they have an ethical or legal obligation to provide information to you as the threat assessment team because of the level of concern they have. With HIPAA, typically the types of medical records that we deal with are not going to be covered in the college-university setting. Student health center records, for example, or student mental health records from the counseling center are usually not HIPAA covered because there's some joint guidance from the Department of Ed and the Department of Health and Human Services, which you can Google joint guidance, FERPA, HIPAA, and it talks about those issues and notes that for the most part, those kinds of records on a college campus or in a school setting are going to be deemed FERPA records, not HIPAA records. So they're going to be governed by FERPA's privacy protections. But you should consult with counsel on that because some more complex institutions with academic medical centers, for example, may determine that those kinds of records are covered by HIPAA. So follow the rules on that. If you have a question, consult with your counsel. I just want to note in this context that HIPAA does have a health and safety exception like FERPA does, and we'll talk about that in a moment. So again, that's something to consult with counsel about. But if you find yourself in a position where you really think, as a threat assessment team member, that you need to have access to that kind of information and someone's holding up HIPAA as an internal person, you may be able to engage counsel in helping you talk through that with them or with an external person as well. If you explain the circumstances, they may be willing to provide information to you. The open records angle to this, I'm going to read as implicating the question of open records requests for threat assessment records. So obviously it varies state by state, and some states are much more aggressive about enforcing the sunshine requirements of their open records laws than others. If you are in a relatively aggressive state, then you're going to have to anticipate that and know well your state's exemptions that are going to vary, again, state by state. There's nothing particular to HIPAA or FERPA that would affect the open records status of records that are about mental health or threat assessment. The only one I'm aware of, and it doesn't mean there aren't others, but I'm aware of Virginia having a specific law that says that essentially threat assessment records are not going to be subject to disclosure under the open records laws. But I have definitely helped folks think through issues in various states around whether they have to produce threat assessment team records in response to an open records request, which is particularly concerning when the request is coming from a person of concern and you're gathering information about, let's say, really concerning stalking behavior or threatening behavior, and you're concerned that providing the information could accentuate the threat. And I think that's a circumstance where you'd look to exemptions like personal information exemptions that say you don't have to provide personal information in some states, student records exemptions. I know that applies in some of the states I work in. Mental health privilege records, to the extent that that might apply to what you have. But talk to counsel in advance, find out how broad your open records law is, talk about the different categories that may apply, and if there is real risk, then you're going to want to make sure you create your records having in mind that it is possible that open records requests might be made. I'll just note again on a related point that students and their parents, when they're K through 12, have a right to see their records if they are FERPA records. And for the most part, your student your student threat assessment records are going to also be student education records that technically they have a right to see upon demand. Now, you have 45 days to provide them, and if I'm putting a scenario out of accentuating or exacerbating a threat of harm to someone versus complying with the FERPA right, I'm probably going to err on the side of holding the records, frankly, because there's no enforcement penalty for not producing those records in the immediate demand. But again, that's something to have in mind. Unless you've got your FERPA records, your threat assessment records housed under your law enforcement unit, which I know at least one school I know of does that. So it's an interesting approach. I'm not sure it would work in every situation, but it's something worth thinking about. But that's the best I can do with this question, because again, you're going to have a lot of variation from state to state, particularly as it goes to open records requests, but those at least are the federal considerations.
Jeff, let me ask one quick clarifying question. One thing that we often see is that I have talked with colleges and universities around the fact that you may be collecting information for the team to analyze, but then when you actually document the case, you don't need to have the kind of raw underlying evidence. You don't have to have, and I think it's probably good not to have, someone's mental health records, someone's student conduct records, that rather what the team can produce for the team's records is kind of a synopsis of, we gathered information from a bunch of different sources to include the following. In summary, this is what we observed, and here's our analysis and assessment. That really, that's what's critical for a team to be capturing from a record standpoint, is that where did we look for information, what did we make of it, and now what are we doing about it, rather than necessarily capturing in those threat assessment records all of the underlying raw data as well.
Absolutely agree. And that's one where you should have that discussion with counsel about how likely is it that we're going to have to produce records in response to a public record request if we're a public institution. I should have said that, but that goes without saying. Or if any institution subject to FERPA, at some point we may have to produce those records. So what is the optimal level of documentation? And I think Marisa has described an optimal approach to documenting and taking minutes of your meetings and to-do lists and that sort of thing. And just on that, and we talked about case management before, when you are creating to-do lists coming out of a meeting, for example, particularly if you don't have a dedicated case manager who's able to follow up, just be very thoughtful about what you put there as to who's going to do what and when. If you're not going to do it on the schedule that you list, you shouldn't be listing it.
Exactly. All right, let's go to the next info sharing question. Is there any guidance, legal or otherwise, to help determine when it would be reasonable or unreasonable to share information among and between various groups?
Okay, and there's various examples here. Law enforcement, non-threat assessment team members, secondary to higher ed. So we'll try and go through those. Secondary to higher ed is the next question, so I'm going to defer that one for the moment, and I know we've got some from the folks participating as well on that, so we will we'll address that. I think I'll start with law enforcement questions. So folks should understand February of 2019, the Department of Education's Privacy Technical Assistance Center put out a technical assistance document called School Resource Officers, School Law Enforcement Units, and FERPA. And it was focused in its phrasing on the K-12 context, but the principles, as noted on the 6th or 7th page of the document, seventh page, they do apply generally to higher ed as well. And they talk quite a bit about the status of law enforcement officers who may not be campus law enforcement or school law enforcement, but instead are employed by an outside law enforcement agency. So that guidance is a good clarification. And what they speak to, and this answers the question generally as well, is you can share information generally without concern about FERPA with school officials with a legitimate educational interest. A legitimate educational interest being a need to have the information to perform their professional responsibilities. And school officials can be broader than just people who get a paycheck from the school. It can also be consultants and outside folks who are taking on duties that would otherwise be performed by someone who works for the school. So it could be attorneys, it could be threat assessment advisors like Marisa, it could be bill collectors, any number of folks, and it can be law enforcement. So if law enforcement can either be on your campus as a law enforcement unit, or you could be working with outside law enforcement if you don't have internal or if you've got some work sharing arrangement. So the question there is, how do we treat outside law enforcement, for example, as a school official with legitimate educational interest? And in that documentation, which you should look at, there's a specific question answer, question 17. It talks about how you ensure that if you're going to share information with law enforcement as a member of a threat assessment team, they've got to be providing security for the school. They're there to provide safety and security for the school, not to do, say, a criminal investigation of other matters. They have to be under the direct control of the school as it pertains to the maintenance of records, not in general as to their law enforcement duties as police officers, but instead you've got some kind of an MOU preferably that says, to the extent that we're sharing student record information with you as our school resource officer K through 12 or our on-site law enforcement, or even you're doing it internally with your campus law enforcement and you want to document it, you are taking that as a school official. You have to maintain the records like we maintain our FERPA records. And here's where it gets a little bit confusing, but we can work through it. They are also subject to the redisclosure requirements, so they cannot walk away from the campus where they gathered information as a school official, walk back to their home department, and then share that information with their colleagues for the purposes of a criminal investigation, because that's not the purpose for which they got it. They got it for the purpose of keeping the campus immediately safe, not for solving crimes or doing investigations. It sounds like a strange distinction, but that's the way it works. But what I can say is this from the examples in the guidance. They could, however, or that documentation could be received by a subpoena. So I think if someone says, hey, I think you might want to issue a subpoena, here's the kind of stuff you might want to look for, that's their view on it. Department of Ed seems to say that's okay. So the documentation could be obtained that way by a subpoena through normal process. As far as other counseling services, that sort of thing, with counseling, they're going to provide to you what they're able to, consistent with their obligations under Tarasoff-type analysis. Is there an imminent threat to specified individuals, whatever the standard is in your state? Remember that you can always provide information to them, and that may help them weigh whether they have the obligation or the duty or the ability under their state law and their ethical obligations to breach privilege from the counseling perspective. Because if they're just sitting with a person of concern or a witness who may be a potential victim, and they just know what that person is telling them, and there's outside information that the threat assessment team knows that's much broader, that if provided to the licensed professional and they put two and two together and say, oh, this does require me to disclose more, then they may be able to do that. I would say, and we always say this, talk with those folks in advance of a crisis to determine what the threshold is that they use, because you want to have an agreed upon understanding as to when they're going to provide information to you as allowed under those applicable laws.
Awesome. All right, Jeff, let me toss this one to you quickly. Can a secondary school communicate to a campus about an individual's previous threat behavior? What and how? Yes,
it can. So again, looking back to the February 2019 technical assistance, there's a specific answer. It's to question number 31, and you can definitely do that. There's provision in the FERPA regulations that says if, and it's a connection with the health and safety emergency exception, it says information, nothing in these regulations shall be read to prevent an educational agency or institution from disclosing appropriate information to teachers and school officials in other schools who have been determined to have legitimate educational interests in the behavior of the student. So that's a FERPA Reg 99.36b3. So if it is determined by a K-12 school that they, another school, and that would include a college, has a legitimate educational interest in the behavior of the student, they can provide information about that. And that's disciplinary records, specifically it's talking about, but I think that could be other information that folks might have, recognizing that if it's personal observation, it's not covered by FERPA anyway. If it's something that did not result in discipline, I don't think you're going to have a FERPA problem disclosing it, even if it's not a health or safety emergency under this legitimate educational interest in the behavior piece. But there is a sensitivity around that kind of information. So if it's a situation where providing it could result in some kind of a defamation claim, invasion of privacy, something like that, it would be better to talk with counsel before you make the disclosure. If you're the campus looking to get information from the prior K-12 school, let's say the high school, have this documentation in mind, have this guidance in mind which cites to the FERPA regulation so that you can go back to the school and say, no, you actually can share this information with us if you think we have a legitimate interest, and of course we do, because we are now concerned this person's on our radar of our threat assessment team. So we're really concerned that there may be some past history that, if we knew about it, could help us better respond to the situation and keep everyone safe. The other piece to recognize is that even absent legitimate educational interest or legitimate interest in the behavior of the student or a health or safety question, you can get information under the FERPA regs where it is going from one school to another school where the student seeks or intends to enroll. So that's even broader. So if it's for purposes of enrollment or transfer, not so much threat assessment, it's more before that, but in the admissions process, you can get information that way too.
All right.
Okay, shall we dive into some questions?
Absolutely.
Okay, for this question break, I've got a group of 3 questions related to mental health issues. First, following the student with schizophrenia example, what are your thoughts on ways to mitigate risk for faculty and staff members with documented behavioral issues, disciplinary actions, but also documented health concerns via family medical leave, and what are the legal implications? That's item 1. Item 2, what is the threshold by which you or your threat assessment team recommends that a faculty or staff undergo an independent fitness for duty evaluation or a student undergo an independent violent risk evaluation? And number 3, to what extent should a known mental health diagnosis impact the threat assessment, particularly given what could be ADA concerns? There's a lot there to unpack, but I think it would be great to bundle them together to the extent that you can. Marisa, you want to start?
Yeah, absolutely. So when we kind of answered generally about when you want to refer someone for a fitness for duty or a violence risk assessment, whether it's it's student for violence risk assessment or employee for a fitness for duty, let me just give you broad level guidance, and that is that have a good understanding by working with whatever mental health professional is on your team about what that assessment is going to get you. Sometimes referring someone or requiring someone to go through an assessment is actually a great tool because A, it sort of puts them on notice that the university or college is concerned about their behavior, especially from an employee standpoint. B, can give very helpful information to the team about how best to reduce risk. So if we think there is some underlying mental health issue or situation or condition or diagnosis going on and that may be somehow contributing to behavior, then it's very helpful to add in a fitness for duty evaluation or a violence risk assessment. But please understand that those assessments tackle different things. So a violence risk assessment just looks at risk of impulsive violence to self or to others. A fitness for duty is this person capable of doing what their job requires? So fitness for duty for an armed police officer is going to be different than a fitness to teach, or we like to look at the Mike Tyson fitness to box evaluation that was done years ago. So fitness for duty really relies heavily on what are the responsibilities and requirements of the job. Can this person fulfill them? Doesn't necessarily look at risk. So the two assessments are different. rely on your mental health professionals on your team to help the team understand what would this assessment get us. But also recognize that sometimes referring someone out, requiring that type of evaluation can be helpful just to get a much better sense of what's going on for this person and what information can we use from those assessments to inform our own behavioral threat assessment, our assessment about their behavior, and especially to inform whatever risk reduction strategies we think might be needed in this situation. Jeff, anything to add?
I think that you framed it right, and I was going to ask you to respond first, because before you get into the legal questions, you really want to understand why are we doing this, because we often see cases where people will reflexively refer someone for a fitness for duty evaluation without really thinking through whether it's going to tell them much of anything about the risk for targeted violence as opposed to affective violence, as we talked about at the beginning of the presentation. And they also aren't thinking through what exactly they're going to do if the fitness for duty comes back positive. It says, yes, the person has passed the test. They can now come back to campus. If you have no other angles on this because you've not done a full threat assessment around all of the things that you might be able to learn optimally about the person's behavior and what's motivating them and what things might trigger further negative behaviors from them, having a stamp of authority from a psychologist or a licensed social worker is not going to be particularly meaningful or even helpful to your strategy. So I think Marisa's talking about ways in which that strategy could help, regardless of the outcome, would be really good, but recognize it's limited in scope. I think all of the issues around legal issues, there was reference to the FMLA, the Family Medical Leave Act, which has people submitting information justifying why they need certain leaves, or the Americans with Disabilities Act, where people either provide information because they seek accommodations or they are protected from discrimination because they either have a disability or they believe that someone regards them as disabled. Again, I'll go back to the idea that primarily we want to focus on their behavior, and we want to focus on doing a broad threat assessment. And if in the course of that we gather information to suggest that they may be suffering from a mental health condition because it has been disclosed, it's probably rare that you're going to get it from the HR through the FMLA documentation. There's no specific exemption for safety issues or that sort of thing. And again, I'm not sure that the diagnosis itself is going to be the determining factor in whether the person is safe, because you're rather going to look at the behavior. But the ADA information, you may get it, you may not get it from your internal folks. Whether they allow you to have it or not, I'll leave that to your counsel to determine whether it's necessary in a circumstance. But I'll say this, if you focus on behavior, you're going to be okay, because courts are quite deferential to employers who need to make decisions about safety-related issues that are behavior-based, even if the person claims that the behavior was caused by a disability. Courts have repeatedly held that threatening behavior, harmful behavior, does not have to be accommodated under the ADA.
Okay, we're ready for the anchor leg. We've got two more topics. Marisa and Jeff, take it away.
All right, sounds good. So we've got one.
Jeff, did you want to dive in?
Yeah, well, I'm going to pitch it to Marisa. We're going to talk about outreach. So what's the best way to advertise a college's threat assessment team to faculty and staff so that the team doesn't receive information about attendance issues or matters that do not reach the threshold?
Yeah, so this is a great question, but it actually covers two different issues. One is, how do you advertise the team to faculty, staff, to students, to parents, et cetera? And there are lots of different ways to do it. I'd say find ways to kind of match your culture, and find ways to get the message out a couple of times a year, as well as maybe having a go-to place like a specific web page for your threat assessment team or whatever you call it. The great examples, I'm not trying to exclude anyone here, but great examples you can go to. Virginia Tech has an excellent threat assessment page. I think it's threatassessment.vt.edu, and they actually encourage teams to copy and paste information from their webpage and their frequently asked questions section, and use it for your own if you want to. Just reference that you got it from Virginia Tech. Tufts has done an excellent job of advertising their threat assessment process. They call it their TTAM, their Tufts Threat Assessment and Management Team. Stanford has a great web presence, and they have separate web pages for information. If you're a student and you want to know what threat assessment is, if you're a parent and you want to know what threat assessment is, if you're an employee and want to know what threat assessment is, very similar information but tailored a bit to those different audiences. So those are just great examples I would encourage you to look at, and content from those sites can help you do your own web page, can help you do email blasts, can help you provide information at new student orientation, new employee orientation, but find ways to get the message out a couple of times a year, at least once a year, maybe a little more, just encouraging people to report. But separate from that, how do you make sure you don't get stuff the team doesn't need? I would much rather that issue be dealt with at the team level. So what can be very helpful is encourage people to report in behavioral concerns, and you can give them examples, threats, any situation that makes you worry about your own safety or colleague safety or campus safety. You can give examples like that. But then at the team level, have some screening questions so the team will only handle cases where threat assessment is appropriate. As an example, we see threat assessment teams who will get referrals from faculty members that really are just a matter of better classroom behavior management, that it's disruptive behavior, but it's not threatening, it's not dangerous. We have seen cases where threat assessment teams are referred matters because someone has a chronic drinking problem and they've had multiple transports to the ER on Friday nights for excessive alcohol consumption. We've seen cases where threat assessment teams get cases about a chronic eating disorder, for example. Those cases are actually best handled through other mechanisms on campus. So if a threat assessment team can develop some good screening questions or develop a clear scope, we will handle cases where there is a threat of violence to others or to self and others. If the only concern is about threat of harm to self, maybe that's just a matter for your counseling center, or maybe that's just a matter for your EAP program. If a team can come up with that scope up front and develop some screening questions that kind of tie in with that scope, it can handle situations coming in and say, yes, this is threat assessment. No, this is just a matter for student conduct. No, this is just a matter for EAP, for example. So especially when teams have high volumes, you can encourage reporting generally, give some guidance in the ways you encourage that reporting, but then at the team level, have some screening questions so you know what you really want to spend your time on using threat assessment and what should actually be referred to other departments.
Great.
So the other question, Jeff, go ahead.
So how frequently, and I'm going to say if at all, would you advocate for reporting on threat assessment and management activities? To whom? How much off-campus outreach would you do?
Yeah, so I think the if at all is important here. What I think is helpful for a team to do is do an annual report that would just go to whether there's an executive committee that oversees the work of the team, or if the team is housed under student affairs, housed under HR, housed under public safety, housed under general counsel's office, whatever entity kind of owns the team organizationally, to at least prepare a report just for internal use that way. It can help to document just how many cases the team is handling year upon year. In that report, I would document what training initiatives, including training for the team there might have been, or general awareness sessions to encourage reporting, any other things that the team did, just to really be able to show the work that the team is doing year upon year. I will tell you, for busy teams, this takes time, and this can be kind of an annoyance to have to produce this type of report. It can be a one-page summary of cases handled, how many were students, how many were faculty, how many were staff, how many were from outside the institution, and then a bullet list of what trainings were going in. It doesn't have to be lengthy, but it can be very helpful to produce that type of a record, but really just for internal use, in case there's ever a question about, well, what kind of training have your team members gone through, what outreach efforts have your team members engaged in.
Great. And I will say that when we do work with campuses and we're trying to help them best decide how to configure the workload between various groups and whether the care team does one thing and the threat assessment team does another, and what are your thresholds and who does what. It's really important to have that data because it can really show patterns of concern or really robust and helpful things. But how you report it out is much more discretionary, but I would definitely say you want to have it for sure. So Marisa, is it a beneficial and or best practice for campuses to have separate, dovetails with my last point, behavioral intervention teams and threat assessment teams? If so, how do they coordinate info sharing, and if not, why not?
Yeah, I'm going to actually combine this with the question below, which is, should there be a different team that assesses threats from a Title IX perspective? And would love for you to weigh in on that as well. So it really is a matter of kind of local jurisdiction for the college or university to decide for themselves if they want a separate team, or for a behavioral intervention team to also include some threat assessment responsibilities. Typically, behavioral intervention teams or care teams have a broader scope. So they would handle those chronic eating disorder cases. They would handle the, kind of multiple trips to the ER for alcohol use. Whether you have one team or multiple teams, what's important is team scope for each of those teams. So if you've got a behavioral intervention and a threat assessment team, sit down with both teams, have both teams sit down together over the course of an hour and decide, okay, who owns what? And make sure that if it comes to the behavioral intervention team, but really the threat assessment matter, create a mechanism to make sure that case gets transferred. The best mechanism I have for information sharing and coordination across multiple teams is having a couple of people who sit on both teams. So they are seeing things coming in from either side of the equation, and they can help be actively involved in making sure it gets to the right team.
Absolutely.
So similarly, and Jeff, I'll have you weigh in on the Title IX issue quickly. The other issue that we've seen with the advent of regulations and requirements around how colleges and universities respond to Title IX and VAWA-type cases, sexual assault reports, stalking, domestic violence, dating violence, we have seen that those may be handled just by Title IX and not get the involvement of threat assessment. What I would say is, if you have a case that is a Title IX/VAWA related issue, you may also have an ongoing safety concern. So in those cases, it's important to loop in threat assessment. And the best way I've seen of actually doing that, so things don't get caught in one silo versus the other, is to maybe have one or two members of a threat assessment team sitting in on Title IX meetings, for example, just from a listening perspective, to hear what's going on, and then also have your Title IX coordinator sit in on your threat assessment team meetings so they have a much better understanding of where the threat assessment team can help them with ongoing Title IX cases.
Absolutely. So Marisa, as you well know, this is one of my favorite topics. I've just posted to the questions and comments 2 resources. One is a book chapter that I wrote that was published in 2015. It's on this topic of the use of threat assessment in sexual assault, dating violence, domestic violence, and stalking cases. And the other is an article that Marisa and I wrote that was published in February in Inside Higher Ed, and it's in response to a particular tragedy, but more focusing on this general idea that, as Marisa suggests, involving your Title IX clery being your stalking, intimate partner violence issues, in addition to sexual assault issues, involving those folks in your threat assessment process, having them at the table so they understand what the process is and how valuable it can be to the work of the Title IX clery function, where they have to make decisions about, do we go forward even though a reporting person doesn't want us to, for example. It's a decision schools sometimes have to make. How do we initiate a disciplinary action? When do we do it? How do we do safety planning? What is likely to trigger a person of concern who may be a respondent in one of these cases? How do we handle disciplinary matters where there may be an ongoing threat of harm that is unique, I would say, to intense, ongoing intimate partner relationships or stalking relationships that the Title IX folks are not going to see in your stereotypical non-stranger sexual assault where the parties don't know each other well. When VAWA was passed in 2014-15, we recognized that they were going to get a lot more information on our campuses about those kinds of behavior, so we would have to be much more robust at responding to them. So the book chapter and the article that Marisa and I recently did really focus on this idea of two different tracks where you have your Title IX clery process that you must do under the law, respond from a disciplinary perspective, do your forensic analysis of what happened when, did it violate our policies, but at the same time, more quickly most likely, do a threat assessment initially and on an ongoing basis, hand in glove with the work of the Title IX investigators and coordinators so that things don't fall through the cracks. And there's some examples of times where it could be argued that that happened, and those are referenced in resources that we've identified. So it's a big issue. It's probably a separate webinar, but we hope you look to those resources and definitely involve your Title IX folks in that process so that they can gain that perspective and the threat assessment depth and the training that the folks have there, because they can't do all this on their own just when they're doing a particular disciplinary case. And initiating a disciplinary case may not make people safer. In fact, it may increase the risk of further violence, just in the way that someone leaving an abusive relationship may be at more risk when they do that in the criminal justice context. So let's all recognize that that is there. There's a tail question here. What if the person in charge of sanctioning is the lead on the traditional threat assessment team? I will just use that as a example to point out that the processes are complementary. They're not the same. And when you gather information in a threat assessment process to help assist the management of a potential exacerbation in a stalking or an intimate partner violence case, you shouldn't be looking to use that without further investigation against a respondent in the disciplinary process. If you unearth information that the investigator in that process should know about, go ahead and have them investigate it, but you shouldn't be taking it over without the full process and the fairness that is required through your Title IX clery procedures. So that is a way of saying, if you have someone who's gathering information about background about a respondent, for example, that's not directly relevant to whether they violated the policy in a particular past case, but would be relevant to a threat assessment, you may not want that person sitting as the sanctioning person, because they may have things in their head about the respondent that they probably shouldn't be using. So you might want to have a backup person to be doing sanctioning in cases where there has been a threat assessment.
All right, Jeff, I'm just going to go through our remaining questions pretty quickly, and so we've got time for our last couple of questions. What campus departments and entities we recommend as regular sitting members of a campus threat assessment team? Essentially, I look to expertise, so I'd like to have someone from campus police or campus security. If you don't have any sort of campus police or security, add local law enforcement. Having someone from student affairs and HR. And having folks from a support capacity, so your counseling center and or your EAP programs, you've got mental health expertise. Beyond that, you can add ad hoc members. It depends if you've got student-focused or employee-focused or one team for everyone, but at least have expertise that is kind of administrative, law enforcement or security, mental health, and then make sure your team has access to your general counsel's office or legal guidance as well. Thoughts on threat assessment team being co-chaired by a student affairs representative and an HR representative? I think that is absolutely fine. My concern would be, as Jeff was just mentioning, if sometimes if you have a team that's chaired by someone who also leads student conduct, that can give the appearance of role conflicts. Similarly, I'm not crazy about teams that are chaired by someone from the counseling center or EAP, because again, that gives at least the appearance of role conflict, even if they're never sharing information that they may have that's confidential. So I think student affairs and human resource, I love the idea of co-chairs, because sometimes our day lives get busy, right? We've got other day jobs as deans, as caseworkers, whatever else that you do besides sitting on the threat assessment team. So having a co-chair can actually be really helpful to just split the work across. Best location for a threat assessment chair or director to be part of the police department. Let me say, if it's going to come from law enforcement and your chair position is going to be there, I actually think that's better if the person is more in a public safety position rather than police. So it is not looking like it is exclusively law enforcement. But Jeff, any quick thoughts on that?
totally agree with that. There's a risk that police could end up taking over the threat assessment team and approaching each case as law enforcement investigation, and there are many, many threat assessment matters that are not involving criminal conduct, and we hope never get there, and that could really impinge on a robust threat assessment process. So I would be very vigilant if you're going to do that to make sure that reporting structure-wise, everyone understands this is about threat assessment, not law enforcement, and that the function of threat assessment is going to report to someone who has authority to continue to take the temperature of that and make sure that it's not shifting unduly in that direction and is maintaining a threat assessment focus.
Excellent. Finally, do we see value in outside organizations performing threat assessments as opposed to the in-house experts? Let me emphasize that the American National Standard that we talked about for colleges and universities that references every college and university having a threat assessment team really was talking about developing an in-house capability. That in-house capability, having a team on campus, a process on campus, can be augmented by bringing in outside experts, particularly for your tough cases. But this really is a skill that you can build in-house, and it can work much faster in-house because you've got people who know the landscape, can get information much faster. One thing that Jeff and I do on a regular basis is we work with the insurance company United Educators, and United Educators for many of their members provide a benefit where they actually, as part of their insurance coverage, cover the cost of using Sigma for a threat assessment, for example. So we're called in to help colleges and universities and some K-12 schools in handling some of their very tough cases. But most cases are usually able to be handled in-house. And then finally, best practices for smaller, under-resourced schools. Creativity is what I recommend. We've seen some community and commuter-based colleges partner with local universities to use their clinical psychology interns, for example, in an internship program, or doctoral students to be a mental health resource if they don't have an on-site mental health resource. Partnering with your outside agencies, talking with them about what resources they may be able to provide. Really the expectation, again, from that national standard is we have to do the best we can with what we have, recognizing that there are many institutions that don't have nearly the mental health resources, law enforcement resources that others do. So if you can be creative in partnering with local resources or looking to something like a telehealth, telemedicine resource for mental health consultation can often be a creative solution to those limited resources. Steve, let me turn it back over to you.
No time for more questions, but both Marisa and Jeff have agreed to answer your questions by email if you'd like to follow up, and Andrea Young has typed the relevant email addresses in the chat room so you can copy-paste them if you like. Thanks very much, Marisa and Jeff, and thanks to all of our viewers and questioners from around the Internet. Check the NCCPS webinars page in the next week or so for a link to the captioned recording of today's presentation, as well as a link to our speaker slides. The brief evaluation survey I mentioned earlier should already be in your mailbox. It will take you no more than 2 minutes to complete. Please do. We read and act on your comments. The next Campus Public Safety Online will take place Tuesday, June 11th from 2 to 3 p.m. Eastern Time. We'll welcome Kimberly Large, Field Representative for the Student and Exchange Visitor Program, who will tell us about that program in a presentation called Get to Know SEVP, an Introduction to Working with International Students. The registration URL is on your screen and clickable, or surf on over to the National Center webpage at nccpsafety.org. That's nccpsafety.org. I also want to alert you to the annual Legal Issues in Higher Education Conference, sponsored by one of our partner organizations, the University of Vermont. The conference features leading experts in higher education law, student affairs, and campus public safety, including Jeff Nolan. The conference spans 2.5 days from October 14th to 16th, and you can attend in person or online. Campus Public Safety Online is brought to you by the National Center for Campus Public Safety, with support from the University of Vermont Continuing and Distance Education and the U.S. Department of Justice. Special thanks today to Andrea Young and Dan Cardella. This is Steve Worona. See you next time on Campus Public Safety Online.